Thank you, Ms. Lane. Questions at all? Any other questions related to it? Yes, Senator Block.
Yeah, well, let me begin by saying we, of course, all realize the critical role dentists play in healthcare in California, and my dental care has always been very acceptable. Having said that, I'd like to read a few sentences from a couple of different articles of the San Diego Union Tribune that came out in January, and then I have a few questions to follow up. First article is titled, "Dentist Kept Practicing After Fire in Face." It begins, in June 2007, the Dental Board of California put Rancho Bernardo dentist Ray Michael Smith on probation for 5 years in response to a series of incidents, including one in which a patient was burned when an oxygen fire line erupted in her face. That was in 1999. This was in 2007, he was put on probation. A week after he was put on probation but allowed to go on practicing, another patient, Stephen Frisch, 15, of Ramona, died of heart failure while sedated during oral surgery. By the time a state administrative law judge and the dental board officially revoked Smith's dentistry and sedation licenses, it was January 2012, and the dental board had spent more than a decade investigating reports of negligence, injury, and death in his care. The other article, also from January, first one was January 24th of this year. This is January 25th of this year. The headline for this one is, "Meth User and Blackout Drunk Kept Practices Going for Years." It begins, a meth-using dentist who kept his license long after he declined to enter a diversion program, a self-described blackout drunk who bounced around from practice to practice, a dentist who defrauded patients for shoddy work and published a photo of a patient and her x-ray in a magazine without her consent. All 3 cases came to the attention of the Dental Board of California, which took years to resolve each case. Increasingly, more than 3 years is the norm, allowing injuries or even deaths to happen in the interim. For the dentist with the meth problem, it was 13 years and several rounds of discipline before he finally lost his license. Now, we've heard about shortage of inspectors and all that. I understand that. So maybe this incredible amount of time that goes on between when some dentists, who are obviously the very rare exception, but when some dentists do horrible things to patients and before they actually get their license suspended, maybe that's reasonable. I'm not sure I accept that, but maybe it is. But my question is, how do we protect patients, prospective patients, when a dentist's on probation? Is there a sign that tells them why the dentist is on probation? If I go into a dentist's office, how do I know if my dentist is on probation? I know, by the way, that there is now a requirement that people are told there's a website they can go to. My guess is virtually no people go to that website. My guess is if we took a survey of 100 people coming out of Ralph's, 98 would say they've never gone to that website, but they all go to the dentist. So I'm not sure that serves any purpose, that website. Furthermore, those who are most vulnerable probably have less access to the web, even if they wanted to go to it, or may not speak English and be able to read that. So what are we doing to protect patients from dentists who are already doing bad things to other patients?
I'll take a stab at it. We do have the notice to consumers, or the notice that is posted in, or should be posted in all dental offices, that not only says a website to go to, but also a telephone number. In the event that they are Spanish speaking, we do have a Spanish speaking line that people can call and check on dentists. For a number of years, we have had license lookup. So it is, if the patients are taking personal responsibility and would like to know about new dentists, they have the ability to go to the board's website and check to see whether any discipline has been taken against a dentist. And if discipline has been taken, all the actions are there and downloadable, if you will.
Now, why make patients go through that? If a dentist is a known meth user, if a dentist has burned, disfigured, and killed a patient, why not have them put up a sign that says that in their office?
To Senator Block's point, when you go into a restaurant in many counties, there's a sign that says you passed. If you didn't pass, there's a sign that says you didn't get an A, you got a C. That lets people know that there's a difference in that restaurant. So is there any other notification provision for dentists who are on suspension or have particular problems, other than going to a website?
It depends on what the issue is. There are sometimes in the probationary orders that come down on a practitioner that they might have to notify the patients that they have to have like a third party present in their instructions, and the patient might have to sign. It just depends on the particular circumstance. But we have had probationary orders where practitioners have had to place that information, and again, every time the patient came and they needed to somebody else present in the operatory, that they would sign. So I have seen that.
Well, and I think that's a very good step. I would like to see that used more. Apparently in these cases, which are pretty outrageous, there was not a requirement that anybody else be in the room, or that patients were even told, new patients told when they came in, or existing ongoing patients, about what had happened. How often, what percentage of the time do you require other people in the room with the dentist?
Not very.
Okay. Why? I mean, why is this, you know, as the chairman said, restaurants, you know if they've gotten a C or an A or B. Dentists, and it's not just dentists. I don't mean to pick on dentists. There's probably the same problems with many other health practitioners and legal practitioners. But since we're talking about dentists, and since the Union Tribune in San Diego, which isn't my favorite paper, but did a really good job on this, since they brought this up, it just begs the question, why are we letting this happen?
I'd say it's a very good question, Senator, and I believe none of the other healing arts boards have anything similar to be able to notify their consumers.
And that brings up the next question that I had, which is the issue for number 9, the patient notifications and record keeping. It seems that my understanding is that a dental practice could be sold to another dentist, and I'd never know about it, and I walk in the door one day and there's a new dentist there, may have my records, may not have my records, and I've never been notified that where my records will be, and I understand there's some responsibility to hold records for a certain period of time or keep them, make them available, and that may not be the case in this regard. So it goes back to notification. So there's some way for the patient to know what the condition one of the office is, whether the office and the practice has been sold. And I can understand why a dentist probably didn't want to make that known to his patients, so he could have a nice transition and was able to sell his practice for whatever the value was determined by those negotiations. So I think it's a question of notification and the public's right and the patient's right to know what they're getting into when they walk through the door of a dental practice. And this applies also, similarly to Senator Bloch's question, to other healing arts professions as well. So.
Right. Senator Hill, we were not contacted by Call Curtis on this particular issue, but we did hear that he was looking into this possibility. Since I've been on board the last 2 years, we have not received complaints from a number of complainants that this situation has happened. I know of 2 cases where 2 dentists sold practices and didn't notify patients. There are a couple of things that could be considered. I think a majority of our licensees consider it a best practice to notify patients of any change, whether they're retiring, whether they're bringing in an associate, whether they're moving. I think most of our licensing population probably know that that's the courteous thing to do. With regard to records retention, the board hasn't gone down the road in terms of determining the number of years for record retention, because we wanted to make sure we weren't in conflict with some of the requirements that insurance companies have. And so we understand that insurance companies range from 7 to 10 years to hold records for dentists to be able to have records available. The board can be looking at this situation in the future, though we haven't seen, since we're complaint-driven, we have not seen this to be a problem. On a few occasions, we have been notified by a storage unit that apparently dental records have been found in storage units because they have been abandoned. If we could track down the licensee and find him, we could actually discipline him for abandonment, but oftentimes they've left the state, so there's really no way to go after them.
Well, go ahead.
Yeah, I don't want to prolong this discussion, but I'd like to know, having brought up these issues, and they're fairly well known to you, these kinds of things that happen, and you can't prevent them because there will always be some small percentage of people who don't do what they're supposed to do. But you can warn prospective patients and ongoing patients about these things. Do you plan to discuss this at a board meeting, discuss the idea of putting up a sign or some warning more visible, more effective than just go to a website?
We will take it on your recommendation to definitely put it on an agenda for a future board meeting.
Appreciate that. Thank you.
And that would be great if you'd also look at the notification of sales of practice and for patient notification. I think that would
We'll
be
be happy to do that, Senator.
an appropriate and I think for good patient relationships and certainly patient protection so that they're not surprised when they walk in and have a problem. And since you're complaint driven, which is certainly understandable, and the resources that you have, it's sometimes challenging that we can be prospective on some of these issues as well to see that we can solve a problem before it becomes one or may be one. So thank you for that. Other questions? Yes.
Yeah, I was just
Dr. Wood.
going back to the issue that Senator Hill brought up regarding the sale of a practice and notification. And I sold my practice a little over a year ago and made sure I notified my patients a month in advance because I didn't want it to be perceived. I wanted my patients to know that I was leaving the practice, who I had given over my patient records or actually assigned to them. But it was also for me, my understanding of the rules of abandonment. I did not want to be responsible for potentially abandoning my patients. It could be, I would think that could be perceived since patients were not notified that I was no longer available to provide care. When I would dismiss a patient from practice, which happened only twice, I had to provide a certified letter that went to my patient to say, I'm asking you to find another dentist, but I remain available for emergency care for 30 days, and your records are available for transfer to wherever you'd like them to go. So I would think that when you sell a practice, if you're not making some disclosure, that it would be potentially abandonment. And I would think would hope there's something in the statute somewhere to protect patients like that, because I think it would be an awful surprise for someone to walk in the door and say, well, what happened? 2 weeks ago they were here. So I don't know if that exists in statute, but it just seemed like a best practice thing from my perspective to be certain about that. And also, I don't recall that I've seen in statute about the retention of records, but I know certainly the IRS standard is 7 years. And I do some consulting for forensics, and it would be really nice if dentists would actually retain the records for longer than that, because I just did a case recently where the decedent had disappeared 15 years ago, so 7 years isn't going to help me, and to solve a case like that.
Well, the board keeps its records forever.
Okay.
Storage becomes a problem, but the board keeps our records forever.
Okay.
So
it would be nice to know if there is something in statute that, regarding the sale of a practice and
there isn't anything in statute to date about sale of practice, but we certainly have the ability to discipline somebody for abandonment. Like I said, the issues that we're seeing are if somebody sells their practice and doesn't notify the patient, if a complaint then comes in, we go to the dentist that had the practice and they said, oh, I sold my practice. And then we go to the new dentist and they said, well, I don't have those records. So we expect that the whole ledger was transferred, yet we're not sure what happened to some of the patients from the new owner.
So that's not considered abandonment then?
We've had 2 cases like that. I don't know that we didn't take that route, abandonment.
Okay.
We went citation and fine for not producing the records.
Okay.
Well, I appreciate you looking into that.
Thank you.
And the board taking an interest in that. We'll move now to public comment. Anyone would care to come forward? Are there others that wanted to speak? Please make yourself available. I see we have 2 names there. These are supposed to speak first or something? They were responding to this. All right. Very good. see, so that should be there. Very good. My mistake. I see an error here that I made. Dr. Lori Gagliardi, California Association of Dental Assisting Teachers, and Claudia Pohl, California Dental Assistants Association.
Yes, would you like us to come up?
Make yourself comfortable over here. If you'd like to sit here, that'd be great, or there. Mr. Valencia, you don't look like either one of those individuals. Okay, very good. And yes, they're perfect. And I apologize for, I was assuming you'd be coming up during the public, but I didn't know you were specifically set on the agenda, so it's my fault.
Senator Hill, we do have a number of dental assistants in the audience that wanted to package their remarks at the conclusion of the second panel. This is your scheduled formal panel for key comments, if I understand it correctly. So we'll move through 3 issues very efficiently. And for the record, I'm John Valencia. I represent the Foundation for Allied Dental Education. It's a coordinating umbrella organization for the California Dental Assistants Association, represented today by Claudia Pohl, and the California Association of Dental Assisting Teachers, represented by Dr. Lori Gagliardi. Just a quick preliminary comment. It is as true, I represented dental assistants education in 2010 and 2011 during the last Sunset Review. And it is unfortunate that, but not at all altogether surprising, that today it is as true that constituents of Senator Block, Senator Bates, and Assemblymember Jones don't have a test location option anywhere in that major metropolitan area south of Camp Pendleton. Those applicants from those institutions have to go to Los Angeles at the nearest point of impact, or potentially the occasional temporary facility that the dental board has brought into being in the Inland Empire, which has since disappeared, in order to exam. And Senator Hill, apropos of yours and many comments by members of the committee throughout the day, the only thing one might have to wait for longer than enforcement action is if you're a dental assisting program applying to the dental board for recognition. In the materials that we've submitted to staff and to each of your offices, we offer a case in point in the Inland Empire where a junior college accredited by the ADA Commission on Accreditation, the same entity that approves dental schools and dental hygiene programs, issued an approval for that particular institution, and for 2 years, it had no accreditation recognition by the dental board. It then only received provisional approval. And 4 years later, they're still waiting for final approval. With that, let me turn over the rest of the testimony to our experts. Claudia Pohl for the California Dental Assistants Association, to be followed by Dr. Gagliardi for KDAT.
Ms. Pohl, welcome.
Thank you. Thank you. Good afternoon, chairs and members of the committee. My name is Claudia Pohl, and I have been an RDA for 39 years, an educator for 31, and am an RDA kit provider as well. As John mentioned, I am speaking on behalf of CDAA. Dental assisting is a legitimate and promising career pathway, predominantly for women, and often for those who need to provide for their families. The obstacles I'll outline today serve as a deterrent to those candidates and prevent them from achieving their professional goals in a timely manner. As outlined in our joint letter to the committee, the CDAA is deeply concerned with the manner in which the dental assisting community has been managed by the Dental Board of California. I will speak to the issue of the licensing examination. As noted in our letter, there are 3 significant issues surrounding the Dental Board's licensing exam process that have seriously impacted dental assisting candidates. The first, the exam process. The Dental Board changed the examination process and the criteria for the RDA practical exam last year. This was done without public comment or discussion during either a dental assisting council or dental board meeting. There was also no communication to candidates, educators, or kit renters prior to implementation of the changes. The result is the pass rate has gone from an average of 84% over the last 4 years to 19% in November. Over 1,800 RDA candidates have failed since April of 2014. There are now candidates who have lost employment due to the failure on the exam. and there are others who have not been able to find employment without their RDA. There are a few letters in the packet that you've received, letters from students detailing that. They've been seriously impacted by the changes in the exam process. Second issue, application process. The board has decided that program directors can no longer certify course completion for their students so they can apply for the licensing exam within the application deadline. When the board staff changed the application acceptance process, this change was again not disclosed prior to implementation. Graduates were notified of their ineligibility after the close of the filing period, causing a delay as much as 5 months before they could take their exams. When the application filing period is set prior to students graduating, it is imperative to allow students to file during that time frame so they can sit for the first available practical examination. The third point, lack of exam sites. Insufficient testing opportunities continue to be a major issue for candidates. Since 2009, the dental board has promised the dental assisting community there would be locations added that would make access to the practical exam more convenient and less costly for candidates. That has not changed, even though the dental assisting community submitted multiple options for a testing site to the board. When discussing this issue with the exam consultant in August, he stated to me that candidates would have to get used to having fewer exams and may well have to drive further. Limited testing locations and date options force dental assisting students, who are often low income, to incur significant travel costs to sit for an exam. And there's a map of the testing sites in the packet that you received. In order to remedy these issues, CDAA would like the committee to consider the following proposals. Establish appropriate calibration for the practical exam, along with a formal candidate handbook, similar to what is provided to dental candidates, detailing all criteria necessary for completion of the practical exam, along with language that will permanently compel a minimum number of testing sites and dates for RDA candidates that reflect exit dates for candidates. Amend existing statute to shift the program oversight, accreditation process, and credentialing and testing function from the board to nationally recognized entities. The Dental Assisting National Board, which is used as a standard in many other states, should be responsible for the administration of all dental assisting written examinations. The ADA's Commission on Dental Accreditation, or CODA, is used throughout the nation for approval and oversight of dental assisting programs. The Department of Education oversees dental education in many states and would be an appropriate choice for oversight. On behalf of CDAA, we look forward to working with the committee to resolve these issues for our profession. Thank you for your time and attention.